very busy in court this week, and so we're very grateful for your appearance in your lunch hour. Could you just introduce yourself and say a bit about your professional expertise in the area of domestic abuse, and state in which capacity you're giving your evidence today?
Yes, thank you very much for inviting me to give evidence today. I am a family law barrister at Goldsmith Chambers, and I specialise in rape, domestic abuse, coercive control and honour-based violence cases. That's what my main area expertise is in. I'm also an expert in FGM, having completed my doctorate on that, and I'm a junior research fellow at Queen's College, Cambridge. I'm speaking in my capacity independently, but as a barrister. I'm not speaking on behalf of Goldsmith Chambers or any other organisation.
Thank you very much, Dr. Proudman. Now, based on your experience, perhaps you could explain to the tribunal how the family courts in the UK currently approach allegations of domestic abuse, and in particular, coercive control.
In my opinion, and as I say, having practiced now for quite a long time in this area, I think broadly speaking, the family courts deal with these very serious allegations of domestic abuse in a very poor manner. I think there's a real lack of understanding and education amongst the judiciary and amongst professionals such as social workers and CAFGAS about the impact of domestic abuse upon children's lives in particular, and also resident parents that have to facilitate child contact with abusers. And there's a real lack of understanding of the corrosive impact of abuse upon children's lives.
So what impact have you noted in your practice that problems resolving allegations of domestic abuse, what impact does it have on the children involved in those cases?
In my opinion, I think that there are certainly examples of children having been harmed as a result. So where there have been very serious allegations of rape or domestic abuse, we know that children are seriously affected if they've been brought up or been exposed to this abuse within the family household. And we know through the Domestic Abuse Act that children are considered victims as a result, even if they haven't been directly exposed. And what I mean by directly is actually seen it themselves. They'll have heard it, they'll understand perhaps some of the more nuanced and intimate effects of domestic abuse. For example, a particular look, or a mother in some instances feeling intimidated by the father from the way that they respond or the tone of their voice. And because I think there's a lack of understanding about that, how it impacts on children, there's been a real risk of harm for a number of reasons. One is that the family courts have failed in some instances to even address these very serious allegations. So there hasn't been fact-find hearings perhaps when there should have been. So the allegations are swept under the carpet and contact is ordered, and effectively, as some judges have said, come what may, and that fact-find hearings are a complete waste of time, as indeed one judge said in B&B, the Court of Appeal case of H&N that was reported this year. And this type of attitude is not uncommon. So that's the first reason. In fact, there not being any findings of domestic abuse, and then effectively the allegations just being minimised as irrelevant to child contact. And second is that consequent to that, contact can be ordered in domestic abusive settings, and mothers are then ordered to facilitate this contact with abusers directly, often on a one-to-one basis, which can expose them to irreparable harm or emotional harm. And it can also expose the children to a lot of harm and having contact in an abusive setting. And third is that when there have been no findings of domestic abuse, as I say, because the courts haven't ordered a fact-find hearing, the child does not want to attend contact, and that's often what happens. They're very reluctant to attend. Then fathers in such situations, as it usually is, will argue that the reason the child doesn't want to attend is because of so-called parental alienation. And in such cases, I've seen residents being transferred from the alleged, or in some cases, the actual victim to the abuser. And that has resulted in really significant harm. I've seen situations where children have been suffering as a result seriously with their mental health, and have been desperate to transfer, in these cases at least, back to their mother's residence with great difficulty. And I think the final point I just wanted to emphasise and raise really is the costs of contact. At the moment, the position, as it seems, is that the courts can decide who pays for supervised contact, which I find to be an extraordinary position, because the family courts have no jurisdiction to decide on child maintenance issues, and anything concerning finances, an application can only be made under Schedule 1 of the Children Act. Yet when it comes to contact costs, apparently the court can make any decision they like under the Children Act, which I find astonishing, I think is wrong in law. And I say that because there's been reports in the media of a victim of rape having to subsidise the contact costs of the rapist. So not only does this victim have to take her child to contact, which perhaps she deems to be unsafe, who knows, but one could imagine and certainly envisage a situation of that nature. But then second, she has to pay for this contact, which clearly, in my view, is a breach of her Article 8 rights and shows a complete disregard for the impact upon this victim, as well as the impact upon the child. And it's another example of further financial abuse and control through the family courts.
Thank you for that, Dr. Proudman. I'd like to interrogate a little bit, if I may, the underlying problems there. So what impact do you say that the reductions in access to legal aid have had on the ability for women making allegations of coercive control or domestic abuse to get access to justice?
Well, very significant problems in access to legal aid. Indeed, even when women are entitled to legal aid, I am contacted on a daily basis with women asking for recommendations or suggestions of who they can reach out to in terms of finding a solicitor, because so few solicitors are available to take on their legal aid cases. And when indeed they have taken them on, there's been an awful lot of problems apparently through perhaps lack of ability to take on the case because of there being such a volume, it's quantity rather than quality of the work. In other cases, many women have suffered enormously because they're just over the legal aid threshold, which we know is already exceptionally low, and so haven't been entitled to legal aid. And in some cases, women have turned up to court unrepresented, and then they themselves have had to attempt to cross-examine the perpetrator in court directly because she has no legal representative. And judges have failed to put in special measures, which is a common occurrence, and failing to engage a PD3AA, failing to put special measures in, failing to have a screen, have evidence by video link, provide written questions in advance, make sure the questions are relevant. And so you have a situation where if there's no legal aid, and I say this on both sides, in fact, not only for complainants, but also for alleged perpetrators, they should also be entitled to legal aid when they meet that threshold, which I think should in fact be more generous, but they should also be entitled to it, because otherwise they're in a position where there's no equality of arms, and they're left in a position where they have to or are able to cross-examine victims. And I know that the Domestic Abuse Act is supposed to change that, but it hasn't yet been implemented. The government's still working on guidance, and so in cases that I'm working on, this situation is still arising and we're no further forward.
Are you able to make any additional observations about further impediments and obstacles to accessing justice for women who are from Black and minoritized communities?
Yes, in terms of the intersectional inequalities, they are vast and significant. They are very serious barriers to accessing justice, particularly during the COVID pandemic. And I say that because I've certainly seen situations where women, often asylum seekers, in fact, have been in hearings remotely, firstly struggle to access the hearing if they don't have access to Wi-Fi. That's very difficult for them, and having to dial in on the phone, so they can't see the judge can't see them, don't have Wi-Fi access. The children are with them because there's nobody else to look after. And I've seen situations where women have brought the children to court and then have been scolded by the judge for bringing children to court, but there's nobody else to look after them. They don't have money available to them to assist with childcare, nor do they have any family or friend support in some of these cases. It's extremely difficult. And then, of course, there's a language barrier as well. And if it's a remote hearing, it can be very difficult with interpreters. You can have 3 or 4 different interpreters on the line at the same time, or attempting, in one scenario, the complainant of domestic abuse was struggling to interact with her interpreter. So I suggested that the interpreter calls her on the phone and the interpreter interprets that way. But then she only had one device available, so then she couldn't be logged into the hearing and also speak to the interpreter, which is another barrier to accessing justice. And then there's the added difficulty of being able to access public funding. If there's no recourse to public funds as well, it can take additionally longer to access legal aid because of that. So a whole wealth of issues. And I have to say, when I've raised intersectional inequalities with more senior members of the judiciary, there's a complete glazing over. I don't know if they've ever heard even of the term intersectionality. I know one person suggested, well, perhaps it's because that term intersectionality is quite difficult to understand. I think you could name it in a variety of different ways and they still wouldn't quite understand the obstacles that BAME women in particular experience in accessing justice.
Thank you. Could you talk a little bit about the experience of women going through the court process when they're seeking to alert the court to issues concerning domestic abuse, particularly in private law proceedings involving the welfare of a child?
I mean, there are an awful lot of examples that I could give. Is there anything in particular that you would like me to focus on?
What are the potential adverse experiences that you've come across for women going through that process?
One of the most serious adverse consequences that I've seen, and I say this in particular in rape cases, is when a mother will allege that she has been raped, and often in a marital or partnership context. And there is an impression that, well, because there's been some consensual sex, therefore one cannot have been raped. She must have consented, it can't have been that bad. It may have been unpleasant, as I've seen it described as deeply unpleasant sexual intercourse, but apparently that's not rape. So there's a lack of understanding about what the definition of rape is in family law, and family law proceedings do not follow the same definition of rape as in criminal law context. So there is no definition, which means that in my experience, judges make it up as they go along. So what does consent mean? What is the act of rape? It's continually evolving and developing. In my experience, it seems to me that there's an impression that if rape takes place in a partnership context, there's less gravity and impact that's attached to that, which is, of course, we know wrong, because they're in private proceedings, because they're not transparent, because these judgments are very rarely published. It's very difficult to show a pattern of behaviour that's taking place in court, particularly amongst our judiciary in writing these judgments. The second point to add to the difficulty in proving rape allegations is the often wealth and proliferation of images and videos that are disclosed in private law proceedings. So in some cases, I've seen fathers produce a number of videos to apparently show consensual sex or to degrade and humiliate the complainant because they are so intimate and because they will know that everyone is going to look at those images or videos. The judge is going to see it, everyone in court's going to see it, it's going to be played out, it's utterly degrading. And many of those videos are completely irrelevant as to whether she consented to sex on a completely separate occasion. Yet there are no rules, no stringent rules, in fact, no rules at all, which sets out when this evidence should be admissible, when it should be disclosed, and what it ought to be relevant to in order for it to be disclosed. It's effectively a free-for-all. And the third point in terms of the obstacles of women accessing the family court, or what I tend to see happen, without a shadow of a doubt, the most common retaliation to any allegation of domestic abuse or similar is parental alienation, which I've already touched upon. And this is a common litigation tactic in virtually every single private law case now. And what that means is that when there are fact-find hearings, the judge is often embroiled then with attempting to look at whether there has been parental alienation on the other side to explain why the child is resistant to contact, as well as looking at where the domestic abuse has happened, which extends the length of the fact-find hearing, provides an alternative narrative, even if it's predicated on a false factual matrix, and allows then almost fishing expedition into this potential scenario arising when we know that parental alienation is a quasi-science. It's not based on any empirical evidence, and the founder of it themselves never even produced any evidence to support this notion of parental alienation. So I find that extremely concerning, because mothers are presenting allegations of domestic abuse, and if they don't have third-party evidence, then they're often worried to do so because they're concerned that parental alienation could be raised and they could lose the residence of their children.
And thank you, Doctor. And have you experienced misuse or misappropriation of court processes by a particular party pursuant to, let us say, behaviours of coercive control?
Yes, I've seen the family court process being used as another form of control, particularly another form of financial control, in situations where perpetrators will be self-represented and mothers are struggling to make ends meet, but nevertheless are working, so not eligible for legal aid, having to pay for a lawyer. And I've seen so many examples of fathers sending an exponential amount of material in terms of correspondence to solicitors with the sole purpose of racking up their costs. In fact, I've seen examples of the fathers even saying that to the mother: I'm going to rack up your legal costs by sending this material to your solicitor so you won't be able to afford your legal team. And in other examples, I've seen situations of an enormous number of court applications being made year after year after year, and the court being reluctant to impose a section 9114 bar to prevent further applications. Frankly, why, I don't know, but I know that's something that the government is looking at in domestic abuse cases. And the courts will continue to entertain these applications because in law at the moment, it's right that there's a presumption of parental involvement in a child's life. I know, again, the government's going to relook at whether that presumption ought to be done away with in situations of domestic abuse. So there are a wealth of examples of that nature where it's used for financial control and further coercive and controlling behaviour. And the example that I gave of fathers disclosing and attempting to admit intimate images and videos is another example of that control through the family court proceedings and judges allowing that to happen.
What impact do you say that the gender neutrality of the court in its approach to allegations of domestic abuse plays?
I think this is one of the single biggest issues, actually. The family courts are very reluctant. In fact, I've never seen them acknowledge, even in the case of H&N, which was solely about domestic abuse and the impact upon the lives of children and indeed parents who have to facilitate that contact. There was no acknowledgement that the vast majority of victims and survivors are women, because of course it affects the vast majority of women. There are of course some examples of men who are victims of domestic abuse, but nowhere near in the same proportion or scale. So it has a significant impact because it completely takes away any of the forms of experiences that women have as a particular group in acknowledging that they are more likely to be victims of domestic abuse, and men in some situations are more likely to be perpetrators. And then as a consequence of that, how they are affected by the court proceedings, and not only being the resident parent, but also being a victim of domestic abuse, struggling as a woman, and the various different layers of structural inequalities that they're experiencing. And then if they're Black, Asian, or another form of ethnic minority, that's often another layer and barrier on top of being a woman and a victim of domestic abuse. So it's a significant issue, and it's one I've never seen the courts acknowledge, that this is a gendered issue. And I think that if they did acknowledge that, I hope, certainly, I'm optimistic that that could go a long way in introducing law, policy, or indeed at least an approach that identifies women as more likely to be victims of domestic abuse.
Thank you. So How do you say then that incorporation of CEDAW would assist with these very serious problems that you've given evidence regarding today?
Well, I think it could assist enormously. I mean, certainly in recognising women's status as often very unfortunately likely to be victims of domestic abuse and experiencing the abuse and through the family court proceedings often very differently as women and as victims, and recognising those barriers and providing redress for them. One of the points that I really wanted to touch upon was the necessity of judicial training on domestic abuse, rape and coercive control in family proceedings. At the moment, it seems that there is no mandatory, regular, rolled out training for all judges. So I include full-time, part-time judges, I include magistrates in that category, and legal advisors to magistrates. In the case again of H&N, it was said by the Court of Appeal that there is regular training in place, and apparently it is mandatory or words to that effect. But actually on the ground, we are aware of many individuals who are colleagues and sit as judges that have not received such training, despite numerous attempts to ask the government and ask senior members of the judiciary about the training more generally in terms of what are the core components, when is it provided and how often. There has been no response. There is absolutely no transparency in terms of the training that is offered. So I have no confidence that training is being provided, and I cannot understand for the life of me why the government or why the judiciary are not willing to provide an outline of that training. We have a better understanding of what training is provided for criminal judges and sexual violence cases, yet we don't have the same level of understanding for family judges. And I don't understand why it appears to be an issue of national security or such secrecy that no one can know. And I would certainly suggest that one of the reasons for that is because this training is not in place. And it's a fundamental key core component for any judge to have a foundation and understanding of domestic abuse. If they don't have that, how on earth can they be making decisions about domestic abuse? They're not trained in it and understand and can recognise and identify domestic abuse. Clearly that cannot be right. You know, if you look at a comparable situation, I wouldn't go to the dentist on the basis that I've broken my leg. Of course they couldn't assist me. And judges similarly who are not trained in domestic abuse shouldn't be hearing these cases because they're not suitably equipped, which is leading to a very serious number of appeals that are having to be made because of such decisions, which is further re-traumatization for women and re-victimizations for them. So I certainly think that CEDAW would go a very long way in addressing some of these inadequacies. But certainly I would submit or suggest that the necessity of judicial training has to be one of the key issues.
So because of all the costs cuts within the court service, there's a great deal of pressure for parties to go into ADR. How might CEDAW help protect women in the context of domestic abuse allegations?
Well, we know that CEDAW prohibits ADR, mediation, however one wants to phrase it, between complainants, victims of domestic abuse and alleged or found perpetrators of domestic abuse. And very unfortunately in the family courts, this is something that is advocated for alternative forms of dispute resolution. We saw it again in the case of B&B, which is one of the 4 linked appeals in H&N, an example there where a mother had a non-molestation order in place, which meant that the father and the alleged perpetrator of rape and domestic abuse could have no contact with her because he was deemed to be such a risk to her safety and potentially the child's safety. So there was a non-molestation order in place. Now, despite that, when she went to court, the judge said a number of times that she should go outside and have a cup of coffee and just sort this out. Have a cup of coffee between the victim or complainant and the alleged perpetrator is an extraordinary thing to suggest from someone in a significant, powerful position over a vulnerable, she would say, victim who was very young and had mental health difficulties. Now, this type of approach is not isolated, it's a common occurrence. And I have heard senior members of the judiciary suggest that mediation could be a fruitful or useful way forward in situations where, in inverted commas, there is low-level domestic abuse, whatever that means. We know that low level of domestic abuse, if that's referring to coercive and controlling behaviour, can be as significant in terms of the impact upon children and women's lives as physical forms of abuse, because it is so insidious and it's such a pattern of abuse and behaviour upon someone's life. It can blight their entire life in terms of their confidence and self-esteem, their worldview, their understanding, their relationship with themselves, their family, their children. It's serious and significant. So to suggest that is really undermining and demeaning the impact of domestic abuse. So I think it could have a significant impact in terms of that, because I see through CAFGAS and other forms of professionals a creeping, suggestive method of having mediation under recommendations.
Thank you very much, Dr. Proudman.